Namaskar viewers. The fortnightly videos we present to you every week to give you total in-depth knowledge about cases happening during a given period. Like in this video, you will get selected cases from the beginning of February 2026 to mid-February 2026. As I have mentioned earlier, my website, guide2ibc.com, is just not meant for insolvency professionals. It's meant for the entire fraternity. And my idea is my viewers know as much as I do. So at times there are topics for which I feel that an in-depth knowledge is required. Like say for instance, dispute. We see pre-existing dispute courts saying that this is not IBC is a summary forum, so we are not going to deal with the dispute. Some disputes are regarded as sham and some disputes are taken. So we need to have knowledge about what a dispute is. With liquidation and other things also, there are many things on which we need a little bit of deeper knowledge. In order to cater for that need, I often go out of the purview of insolvency bankruptcy code and search cases so that I can bring to you the full knowledge. So this particular video has many such topics. So I hope you will enjoy the video. Let me take you over to the presentation.
Viewers, you can see on your screen the dashboard of section 5, subsection 6, which is pertaining to dispute. We are coming to topic 14, which says that where the court finds that there are serious allegations of fraud, or where the allegations of fraud are so complicated, which need to be decided based on voluminous evidence, the court can sidetrack the arbitration agreement and proceed with the suit. The case is of 2nd February 2026 of Supreme Court. The case title is Rajia Begum versus Bordali Mukherjee. The topic I have already read, let me read it out once more. Where the court finds that there are serious allegations of fraud, or where the allegations of fraud are so complicated, which need to be decided based on voluminous evidence, the court can sidetrack the arbitration agreement and proceed with the suit. Now, this is not an insolvency bankruptcy court case. This is a case of pertaining to arbitration and contract act, to be honest. The fact is, the appellant Bordali Mukherjee, along with Aftabuddin, respondent 2, and Raihan Iqbal, respondent 3, constituted a partnership firm styled as Messrs. Riddhi Gold by a virtue of partnership deed dated 1/12/2005. Rajia Begum, respondent 1, claims that respondent 2 and respondent 3 executed power of attorney on 17/4/2007, empowering her to manage the affairs of the firm on their behalf, and pursuant to which she executed a deed of administration and retirement by which respondent 2 and 3 retired from the firm. Now, the appellant in 2016 approached the firm and said that this has to be taken over by a company called Riddhi Gold Private Limited, pursuant to absorption deed dated 27/2/2011. And on 2nd October 2016, the respondent 1 issued a notice to the appellant asserting that on the basis of the admission deed dated 17/4/2007, she acquired the interest of to the extent of 50.33% erstwhile partnership firm and then respondent 2 and 3 has retired from the firm. To which obviously Bornali Mukherjee objected. It went to High Court, and High Court initially suggested that they should appoint an arbitrator. Now, this is a very interesting case. And this has a wide application, rather, I would say, not only in arbitration, but in IBC also. Because IBC essentially deals with disputes. So let me stop the screen share here and take you to the slide. So, court was of the view that there was definitely something very there was possibility of fraud existing in the whole thing. Or there were, and Bornali Mukherjee did assert that allegations of fraud. And the court said that where there is allegation of fraud, or where the matters are so complicated, the fraud angle of fraud is so complicated that it needed voluminous evidence. The court can sidetrack the arbitration altogether. In cases where fraud goes to the validity of the contract itself, which contains an arbitration clause, the validity of the arbitration clause needs to be checked. Or in cases where the plea is taken that of non-existence of arbitration clause in the agreement, the same would amount to serious allegation of fraud and would render the subject matter and an agreement which is not non-arbitrable. So, in short, when allegation of fraud is made with regard to arbitration agreement itself, such dispute is recognized as a dispute, and such dispute is in the realm of non-arbitrability, and the court will examine it as jurisdiction and issue to inquire whether the dispute has become non-arbitrable due to one reason or the other. Now, look at this particular case. At the heart of the controversy lies the admission deed, which said that respondent 2 and 3 had retired, which is relied upon by respondent 1 and as the source of our induction in the firm, as the foundation of arbitration agreement. The court looked into cogent materials of various bank transactions and things, and which showed that, which gave a detailed requirement for a full-fledged inquiry. It was showed that respondent 2 and 3 were very much active in 2007. So if the respondent 2 and 3 were very much present, then they could not have possibly retired from the firm. So where the arbitration, Supreme Court held that where the arbitration agreement itself is alleged to be forged or fabricated, the dispute ceases to be merely contractual and strikes at the very root of arbitrational jurisdiction. So this is a very important judgment, though not pertaining to insolvency bankruptcy code, but we need to keep it in view because this can be applied to insolvency bankruptcy code, and not only with regard to section 60, not only with regard to simple disputes, with regard to section 66 matters also. So with this, I take you over to the next topic. Viewers, you can see on your screen the dashboard of section 7 of Insolvency Bankruptcy Code. The topic is section 7 deals with initiation of corporate insolvency resolution process by financial creditor. We are coming to topic 67, which deals with CIRP to be initiated against group companies. And our attention is to the recent case of Satinder Singh Bhasin versus Colonel Gautam Malik and others, civil appeal number so and so of Supreme Court. This is a very recent judgment. In this judgment, what happened was both the developer and the marketeer, CIRP was instituted against both of them. And that is why this particular, and this is a Supreme Court judgment, so that is why this is very important. And we should keep it in mind that this is possible. And this is a landmark judgment which I think every one of you should go through. You don't need to go through the entire judgment. If you wish, you can, but you can go through the excerpts of the judgment featuring on the website, which will give you a brief shell. Now, I'm taking you to the slide which I prepared for you for this. As I said, CIRP may be initiated against group companies. In this, the Supreme Court held that the crucial date for ascertaining whether the threshold, you know that in Section 7, the threshold for a home buyer to institute corporate insolvencies, there should be at least 100 home buyers or home buyers having 10% of the claim. So in this case, there were 103 home buyers. Initially, there were complaints that there were about 143 home buyers, some of whom went out. There were joint ownership and all that. So ultimately, the court held that it was only after registration of company petition, which has taken place under Rule 28(4) of NCLT rules, that it would be impermissible for the petitioning alleges to make any changes without the leave of NCLT. Meaning that once a case is registered and it has been numbered, then it will be impossible to change the list of petitioners without the permission of NCLT. Now, what we see that UPSDA had given lease of the land to Bhasin Limited alone in 5/8/2006. And Bhasin Limited created a company of Grand Venezia Limited in November 2009, barely a month before the construction started. Thus, it had no experience as a marketeer and was incorporated solely for the purpose of entering for agreements for the subject project. And Grand Venezia Limited purchased 1,114 units of the project from Bhasin Limited. They were, as far as the demand notices, possession letters issued by Bhasin Limited to allottees of Grand Venezia Limited, and the correspondence communications with allottees were done by both the companies interchangeably. Payment receipts also manifested the same. That is, both Bhasin Limited was issuing payment receipts as well as Grand Venezia Limited. So the court held, Honorable Supreme Court held, that NCLT and NCLAT were therefore justified in concluding that the corporate debtors were intrinsically linked and that it would have been in their best interest to have joint insolvency process to maximize asset realization. At the end of the day, all IBC process aims towards asset maximization. So it was absolutely justified to institute CIRP against both Bhasin Limited and Grand Venezia Limited. Now, then subsequently it was found that neither the construction was completed, nor the units were delivered to the allottees, fulfilling necessary formalities regarding completion of the building of all respects. So this was also a defect. In fact, NCLAT had deployed a team to make an inspection, and UPSDA also deployed a team, and they found that buildings were not complete. So there was a defect. And so the company petition instituted under Section 7 of the Code against both corporate debtors by the allottees of 103 units was maintainable on all counts. And Honorable Supreme Court held that no error having been committed either by NCLT in admitting company petition, nor by NCLAT in confirming the same in appeal. Now, in this case, Satinder Singh Bhasin, the owner of Bhasin Limited, had proposed to deposit 15.62 crores so that, you know, all problems could be looked into them, the default could be covered, and which was rejected by NCLT. The Honorable Supreme Court held that considering the circumstances, NCLT was justified in rejecting the offer made by Satinder Singh Bhasin. And because it did not warrant, and the order did not warrant any further uh, further interference in this matter, because the things were incomplete, and 15.62 crores, nobody could make an eye estimation as to how much would be required. The building was not complete. So this is a very important case, and I think you should go through it and enrich your experience. With this, we move to the next topic. Viewers, you can see on your screen the dashboard of Section 7, which is initiation of CIRP by a financial creditor. We are coming to topic 149, which says that when facts brought on record by a financial creditor indicate that an amount having been received by a corporate debtor has not been refunded, the fact indicates that the corporate debtor may require resolution. The case is of Vinita Agarwala and others versus Power Pack Steel Private Limited. Though this case is of 2022, the judgment came out on 4th of February. Let me read out the topic once more. When facts were brought on record by financial creditor indicate that the amount having been received by the corporate debtor has not been refunded, the fact indicates that the corporate debtor may require resolution. You will find the case excerpts of the case here. In this, what happened? A loan was given by somebody to a corporate debtor. NCLT Cuttack was of the view, relied on Section 73 of Companies Act and related it to Section 23 of Contract Act 1872, and concluded that the transaction entered by financial creditor was void. And if a transaction is ab initio void, the question of debt is not there. And if the question of debt is not there, then the default also does not arise. So the matter went to NCLT. This is a very elaborate judgment in which the Honorable NCLT has mentioned, has elaborated on Section 5.8, has elaborated on Section 73, as you can see, has also gone to Section 76 of Companies Act. They have analyzed companies' acceptance and deposit rules 2024, 2014, and definition 231, what deposit means, then Section 76A, and then have come to the conclusion. And also they also analyze what claim means under Section 3, subsection 6, insolvency bankruptcy code. So this is a very interesting read. So I would recommend that my viewers kindly go through the excerpts of the judgment. Now, let me stop the screen share here and take you to the slide. Viewers, you can see the slide on your screen. In this case, what happened? The corporate debtor received an amount of rupees 40 lakhs through a bank transfer from an entity. The business loan was extended, which carried an interest of 15% per year annum. Corporate debtor paid interest and deducted TDS thereon. So by paying interest, the corporate debtor admitted payment of interest and as well as receipt of the amount from appellant, and therefore the establishment of debt and debt having been disbursed for time value of money was established. Now, as we know, the adjudicating authority in the impugned order relied on Section 73, subsection 1 of Companies Act, and also relying on Section 23 of Contract Act 1872, concluded that the transaction entered by financial creditor are void. Now, NCLAT was of the view that IBC has been enacted to consolidate and amend laws relating to reorganization and insolvency resolution of corporate person in a time-bound manner for maximization of the value of assets of such person. So, when financial debt within the meaning of Section 5(8) of IBC and default has been committed by the corporate debtor, relying on Section 73 and rejection of application under Section 7 cannot be held sustainable. Because it shows that the corporate debtor has received money, or rather a financial debt, and there has been a default. So we are not essentially concerned with Companies Act. A default debt is there, a financial debt is there, and a default is there. So obviously, as per innovative ICICI Bank versus innovative industries, the insolvency corporate CIRP should follow. So NCLAT held that the adjudicating authority committed error in rejecting Section 7 application, relying on Section 73 of Companies Act, and the order passed by adjudicating authority is unsustainable and deserved to be set aside. So the order was set aside and the matter was sent back to adjudicating authority to be adjudicated afresh. So this is an interesting read. With this, we move to the next topic. Viewers, we are still on the screen. We are on the dashboard of Section 7, that is insolvency, CIRP instituted by a financial creditor. We are coming on a very common topic of topic number 33, that a person duly authorized by the financial creditor can move Section 7 application. There have been quite a few cases. This is the judgment which came out of NCLAT on 5th of February 2026, which is Shrey Equipment Finance Limited versus Roadways International Private Limited. In this, what happened was adjudicating authority established. It was clearly established. Debt and default were clearly established. But yet, Calcutta Bench 2 of Calcutta NCLT rejected the application simply on the ground that the person moving the application did not have the power of attorney or the authority to move the application. This is a nice case. Needless to say that I would request you to go through the judgment as appearing on the website. Let me stop the screen share here and take you to the slide which I have prepared for you. Now, as we know, many of us know that Shrey was put into insolvency by Reserve Bank of India, and they had appointed an administrator by the name Mr. Rajneesh Sharma. So the management of ACFL, that is Shrey Equipment Finance Limited, was vested with Mr. Rajneesh Sharma, administrator. And that administrator, in turn, authorized Mr. Sohan Jha, an employee of ACFL, to take action in legal matters. The power of attorney document of 28/3/2023 shows that the administrator authorized Sohan Jha to execute, perform all acts, deeds, and things for the purpose of the company in any court of law, judicial, quasi-judicial authorities until 31/3/2024 or so long as he remained in employment. Now, after the resolution plan was approved, naturally the insolvency professional or the administrator left. So in between came the the monitoring committee, interim monitoring committee. So interim monitoring committee shall be deemed to have all the powers of the RP under IBC, authorized, and is authorized to exercise all such powers of RP. So the minutes of the second meeting of IMC made it clear that IMC was fully aware of the authorization made by the formal administrator. IMC also authorized Sohan Jha on behalf of the appellant by resolution dated 17/8/2023. The conferment of the IMC giving validity to filing Section 7 petition on behalf of the appellant by Sohan Jha. And further, the said agency, this is a kind of an agency because you're authorizing somebody, was not revoked or terminated under Section 201 Indian Contract Act 1872. Later, after this, the IMC's period finished. The new resolution applicant came in and they appointed a new board of directors. So when the IMC was subsequently dissolved on 26/2/2024, the board of directors in the very same day ratified and accepted all the acts of the IMC by way of a board resolution, including POA, in favor of Mr. Sohan Jha. Now, we come to a very important phrase. The word ratification, by the definition, means making valid an act already done. Furthermore, ratification relates back to the date when the original act was so verified or ratified. The adjudicating authority in the impugned order has returned the finding that the debt and default stood clearly established on part of the corporate debtor. Hence, the NCLAT held that the ground for rejection of application under Section 7 of IBC was erroneous and appeal was allowed. So this is a very interesting case. And this kind of topics will definitely arise. Though this is a Section 7 petitions, as I've told you, appears number of times. But this is not usual. This is regarding power of attorney. So this makes it an interesting read. And I would suggest all my viewers to go through the judgment. With this, we move on to the next topic. Viewers, we are now taking up a very interesting case. But before coming to the topic and the case, I would like you to have a look at subsection 5 of Section 30 of Insolvency Bankruptcy Code. Now we see Section 30 on our screen. Let us come to subsection 5. Subsection 5 of Section 30 says the resolution applicant may attend the meeting of the Committee of Creditors in which the resolution plan of the applicant is considered, provided that the resolution applicant shall not have a right to vote at the meeting of the Committee of Creditors unless such resolution applicant is also a financial creditor. This particular line is very important. Provided that the resolution applicant shall not have any right to vote at the meeting of the Committee of Creditors unless such resolution applicant is also a financial creditor. Now, let us go to the topic. We are coming to topic number 84. You will find this in the regulation 39 also. Topic number 84 says the supremacy of commercial wisdom cannot be extended to shield a process that is fundamentally flawed due to conflict of interest, violation of Section 30 subsection 5 of the code, and absence of procedural safeguards. The cases of Pragiti Construction versus Committee of Creditors and another. It is an NCLAT matter, very recent. This is a very interesting case. This is an exception of exceptions. Long judgment. I mean, this is really an exceptional case. So let me, in order to make it brief and in order to summarize the thing, let me take you to the slide which I prepared for you. Now, in this particular case, what happened was there was no financial creditor in the committee of creditors. There was one operational creditor enjoying 100% voting right. The operational creditor presented a resolution plan. Since they constituted 100% stake, they approved the resolution plan. Another party had, and this particular operational creditor in the resolution plan had offered a consideration resolution amount of 1 lakh, whereas the appellant had also submitted a resolution plan in which he had offered 20 lakhs. But for reasons best known to the committee of creditors, they did not even discuss. They passed the plan of the committee of the operational creditor. Now, the court held that the question of commercial wisdom of committee of creditors is meaningless in this situation and is in express violation of section 30 subsection 5 of the code, and such approval of COC is void ab initio. The resolution professional on its part did not carry out proper evaluation of the appellant's plan and did not prepare or place any evaluation matrix before the committee of creditors as required under regulation 39 of CIRP regulations. The voting process was also not conducted fairly, as both resolution plans were not placed for consideration of the COC at the same time. The appellant's resolution plan was not fairly or objectively evaluated. No proper evaluation matrix was applied. Relevant material information was not shared, and the appellant was not also invited or permitted to attend the COC meeting. The failure to invite appellant to the meeting, coupled with predetermined rejection of resolution plan, amounts to denial of a meaningful opportunity and constitutes clear violation of principle of natural justice. The court here used a Latin phrase, the maxim nemo judex in causa sua. That means that no person can be a judge in his own case and is not a mere technical rule. It is not a mere technical rule, but a fundamental principle intended to preserve the integrity of adjudicatory and decision-making process. NCLAT came heavily on RP's failure to take note of section 30 subsection 5 and also violation of regulation 39, and they observed that the matter should be brought to the notice of IBBI for appropriate action. They also criticized the adjudicating authority, having failed to note the provisions of section 30 subsection 5 of the code. Had it taken the note of the same in time, this proceeding would have ended much earlier. This was waste of time and such a farce. But this is an exception of exception case. So I would recommend that my viewers should go through this case. This is really interesting. So with this, we move to the next topic.
Viewers, we have come to the middle of the video presentation. I hope you are liking the cases which have already been shown to you, and more are likely to follow, and I hope you will enjoy them all. Though this video gets little long, but for about an hour, but please hold patience and do like. Let me have your comments and like, because your likes motivate us. The entire team gets motivated. And if there are comments, please let us have your comments, and share the video, please, with your friends, relatives, and those whosoever are somehow connected to insolvency bankruptcy code.
Viewers, you can see on your screen the dashboard of section 54 of IBC, that is dissolution of corporate debtor. Many of you may object, or many of you may find it a little peculiar as to why I'm taking this topic. Because this does not really, though this is a part of liquidation, but this does not really affect us. But come to think of it, it does, and it may. So this is a judgment of 5th February 2026 of Honorable Supreme Court. The topic is scenario or eventuality that may arise if a real estate company goes into liquidation. The cases of Sachin Patel and others, and another versus Uday Dalal and others, civil appeal number so and so of Supreme Court. This is the case. It's a very interesting read. Very interesting read. This deals with a property in Mumbai, which was vested with a company, which went into liquidation. Now, this liquidation was through High Court. But as you know that now, all the jurisdiction of liquidation comes to NCLT. So what happened with High Court may happen with insolvency bankruptcy court also. And that is the reason, and this is an eventuality which may arise, and especially pertaining to home buyers. So that is the reason I have picked up this case, and I thought of sharing it with you. So with this, while suggesting you to go through the excerpts of the judgment, which is there on the website, I would rather take you to the slide which I have prepared for you. As you can see on your screen, let me read out the topic once more. Scenario or eventuality that may arise if a real estate company goes into liquidation. Now, this particular company belonged to a lady who had given it to a company to run the premises along with other businesses. This lady died, and eventually this company went into liquidation. This company had a liability to the extent of 61 lakhs on account of PF, gratuity, and to other companies also, which had to be settled. Now, the building comprised of 7 flats, occupied by 7 tenants. So the 7 tenants, they formed a cooperative society. 6 of them actually formed a cooperative society and approached the court that why not we pay the debt? And in exchange, you transfer the ownership to us. The court agreed, and the official liquidator, after receiving a consideration of 15 lakhs, transferred the property in the name of the chief promoters, and the estate was rechristened as Marlborough Cooperative Housing Society Limited. But however, one gentleman by the name Sri Narendra Patel, who was a successor of, or who used to stay there, he declined to pay his share of 5 lakhs. And automatically there was problem. Now all the other 6 had paid. The 7th person declined to pay. He said, no, I would rather prefer to remain in that. So the company went into difficulty. They ran to the Deputy Registrar of Societies. Deputy Registrar of Societies deputed an administrator. The administrator came and took charge, and he was told that you collect the money and you pay it to the court. He said, no, that is not our duty. So they again ran to the Deputy Registrar. The Deputy Registrar told the administrator that he has to collect the money and deposit and do things. But at the same time, it was told that this Sachin Patel, who was the legal heir of Shri Narendra Patel, the court said that why don't you issue shares of cooperative society to this person. While this was being discussed, this guy, this gentleman or this lady, sold the apartment to one Messrs. Capital Mind Advisory Private Limited through a registered sale deed. And the money came to the society. Now the question became as to whether this Capital Minds Advisory Private Limited could become a society member or not. The matter went up to Supreme Court. Now, Supreme Court was of the view that denial of the appellant's request for grant of membership would create a serious anomaly within the subsisting and creating a subsisting tussle and friction with the remaining occupants. Because you don't give the membership and the six other, so the six on one side and one on the other, and there'll be perpetual nuisance. There'll be perpetual friction. So in order to resolve the issue, the court said that it's better, like whatever has happened. In the backdrop, the only equitable solution will be to recognize the entitlement of Sachin Patel and Bhavni Patel as members of the society, which would recognize the sale to Messrs. Capital Mind Advisory Private Limited, and thereby the membership of Capital Mind Advisory Private Limited gets regularized. However, court gave permission to the other members, the aggrieved members of the society, may move an application before the appropriate authority or body for determination of a suitable additional amount payable by the appellants by way of enhanced interest for the significant delay in making contribution. Because they kept the other six hanging and the whole thing went into jeopardy. So, come to think of it, the liquidation part ended with official liquidator handing over the possession. But the full money did not come. Only money to the extent of 15 lakhs came. And thereafter, maybe another 6 lakhs came. But the entire money, the money of Narendra Patel or heirs of Narendra Patel did not come. So the matter kept hanging. Till the matter went to Supreme Court and Supreme Court decided the issue. So this is very much, I was not sure whether to put it in section 54 because this is not exactly dissolution of a company. This does not come under section 53 because this does not deal with distribution of funds. This does not come under regulation 33. This is not sale of property, auction of property or say private sale of property. However, this is not also dissolution of company. But this is a scenario which can very well happen in the case of a company going into liquidation, a real estate company comprising of homeowners, because there are multiple interests involved and which may not be in concurrence with each other. So this is an interesting read. With this, we'll move on to the next topic. Viewers, you can see on your screen the dashboard of section 99. This particular case, which we are going to refer to, deals with essentially section 100. But there are some very vital points. This is not an exceptional case, but I have selected it because it defines the steps of insolvency process for personal guarantors. So this also deals with section 99 as well. So let us go to the topic. The topic says, though RP is a facilitator in the process, the PG should provide information, explanations, especially since till this stage, the debtor had opportunity to provide information or explanation to substantiate their contentions. The cases of Harish Kumar Mittal versus State Bank of India, a recent judgment. As I said, there are multiple questions in this. This is a long judgment, but I would rather not call it an exception of the judgments. But this is important because it clarifies a lot of questions and doubts. So let me stop the slide share here. I mean the screen share here, and let me take you to the slide share. I have already read out the topic pertaining to section 99. I'll read out the topic for you for section 100. The matter relating to existence or non-existence of pre-existing dispute is irrelevant for the purpose of admission of an application under section 7 or section 95 of the code. Now, there are basically 3 or 4 questions answered in this particular case, highlights. First, State Bank raised a question that the appellant doesn't have a locus to file a Section 61 petition. The NCLAT was of the view that Section 61 states that when a person is aggrieved by an order of NCLT, he has every right to come to knock the doors of NCLAT for justice. So the objection of State Bank was overruled. Now, the personal guarantor had said that, complained about a lot of things, that their guarantee deed was not properly stamped, the State Bank had not given full information, there was pre-existing dispute and all that. So the court was of the view that there are two distinct parts. Though RP is a facilitator only, but NCLT judges takes a view on Section 100 based on the report of RP, though that can be contested by the personal guarantor. So the submission of information or explanation stage begins and ends at the time of when RP is inquiring information. If you do not serve the information to the RP, then your chance is gone. Your chance is gone. So 99 becomes very important here. It's not that you do not submit information and explanation at the time when RP is inquiring for information, and then you come to NCLT and furnish fresh information. NCLT may not consider that because RP may not have considered that particular information. And at appellate stage, NCLAT will not take those into account. So long they also had filed a petition that their reply was not, they had filed a reply affidavit which was not taken into consideration. But then they looked into the matter and said that they were given a reasonable opportunity to address their issues. So there was no question of uh, there being any shortfall in the terms of natural justice. Then came the question, and also it was stated that the Code of Civil Procedure 1908 and Indian Evidence Act of 1872 do not strictly apply to the proceedings before adjudicating authority, while adjudicating authority is dwelling on a petition on Section 95 and leading to Section 100. So we have seen in umpteen number of cases that shortfall in stamping and all that is not of so much significance. What is of significance is debt and default. So this petition was admitted. But this is an exception. And also there was a question of pre-existing dispute. Now we know the pre-existing dispute comes in the case of Section 99. That is operational debt. And this is a petition filed under Section 95, which is essentially filed by a financial credit. So pre-existing dispute has no relevance whatsoever in admission of a case under Section 7 of Section 95. So this is important because though in this particular case, nowhere Section 99 has been mentioned, but it magnifies the importance of the assessment being done by the RP and the relevance of under Section 99 of the code. So with this, we take you over to the next slide. As you can see on your screen, the dashboard of topics under Section 238 of Insolvency and Bankruptcy Code. We are coming to a verdict of Supreme Court in a case which was possibly delivered yesterday, that is 13th of February 2026. Now, the topic which we are going to discuss is essentially it is necessary for the constitutional courts to recognize their respective provinces of IBC and TRAI Act and to ensure that they operate with harmony and without conflict. This is a fabulous judgment, a very long judgment, but basically in the end part, the judgment deals with whether IBC can be operated in the matter of spectrum. So State Bank of India versus Union of India and others, Supreme Court judgment. This is a real elaborate judgment because we know that ARCL and others, there have been a number of cases ending up in going to NCLAT pertaining to and companies with spectrum license going insolvency and then resolving them has been a difficult proposition and which has been hanging. And as you can see, this is case of 2021. So this is a very, I would say this is a wonderful judgment of Supreme Court, but we need to understand the highlights. So I'm stopping the screen share here and taking to the slide which I prepared for you. Now, this particular case analyzes the essence of the thing. So what does it say? The spectrum is an intangible asset, thereby triggering the application of special statute, the IBC, which operates notwithstanding any other law to the contrary. An intangible asset is is an identifiable non-monetary asset without physical substance, held for the use of production or supply of goods or services, rental, for administrative purposes. So it does not have any physical subsistence. Spectrum licensing rights are identifiable as they are separable and can be sold, transferred, licensed, exchanged, either individually or together with other underlying contracts. The expectation of future economic benefits from the licensing right is also probable as TSPs develop infrastructure under the state policy and provide telecom services to the public. And we know that accounting system, we have accounting system to recognize intangible asset in the financial statement. And how is it done? By calculating the probable cash flow from it, vis-a-vis reliable measurable cost to acquire such asset, and the licensing fees and etc., which are to be paid therefore. Even the cost of the spectrum license can be measured under the separate acquisition method comprising of acquisition cost, auction price, license fee, non-refundable duties and taxes, and any expenditure incurred to make the asset ready for the intended use. Now we come to IBC. IBC explicitly excludes from its scope of insolvency and liquidation framework assets over which corporate debtor does not have any ownership rights. In the context of assets in liquidation, it excludes assets held as part of operational transactions, where entity has rights over the asset but not the ownership. So Section 36 specifically excludes such assets. The scope of IBC, scope and ambit of IBC is to speed up the process providing insolvency and achieving maximization of the value of the assets of the entity undergoing the CIRP. The scope or the focus is on the company. Whereas Telegraph Act, Wireless Telegraphy Act, TRAI Act forms a complete exhaustive code for all matters relating to telecom sector. This includes declaration of nature of rights, liabilities arising out of holding or using such spectrum. Taken together, we know that who's the ultimate owner of spectrum? It's the union. So, taken together, union as the owner and trustee of spectrum on the one hand, and TRAI as the regulator on the other, occupy entire province of telecommunication. Clear. TRAI controls entire province of telecommunication. The disharmony caused by applying IBC to telecom sector, which operates under a different legal regime, was never intended by the parliament. Because the very concept, the intangible asset, firstly, intangible asset, the ownership of the asset ultimately lies with the government. Both Section 18 and Section 36 they do not include assets which are not owned by the corporate debtor. So IBC doesn't. So there is a complete disharmony between TRAI and IBC. So it was never intended by the lawmakers to make IBC applicable on spectrum matters. It is necessary for the constitutional courts to recognize their respective province for IBC and TRAI Act and to ensure that they operate with harmony and without conflict. This is a beautiful judgment. I would strongly recommend the viewers to go through it. Viewers, we are now in the dashboard of Section 238A, which deals with limitation. What we are going to deal with is not a case of insolvency bankruptcy code. But limitation, as we know, the 238A says that law of limitation applies to insolvency and bankruptcy code. And we have had so many topics, so many cases dealing with limitation. So we need to have an idea about what Limitation Act wants to do, or what is the purpose of Limitation Act. So the case which we have taken gives a wonderful view of how limitation works. Now, the topic is 83, which says that if one has obtained a relief just or immediately when the cause of action had arisen, the other person cannot take the benefit of the same by approaching the court at a belated stage, simply on the ground of parity, equity, sympathy, and compassion. Let me read it out once more. If one has obtained a relief just or immediately when the cause of action has arisen, other person cannot take benefit of the same by approaching the court at a belated stage simply on the ground of parity, equity, sympathy, and compassion. The case is of Patpati Subba Reddy Diet versus Special Deputy Collector. This is a Supreme Court judgment. It's a beautiful judgment because often question used to arise to me as to we see a limitation pertaining to filing of an appeal, filing of a petition and things like that. But what happens in the case there is a judgment? Does it stay forever? So these questions are bound to come in mind. So in order to find that out, I was looking for a case, Supreme Court case, and this is a wonderful case which I chanced upon. I would like viewers to go through this particular case excerpts because this will give you an in-depth knowledge. So let me take you to the slide which I prepared for this purpose. What we need to understand is that laws in India are all curated or promulgated, keeping in view the public welfare. Though a question may come, does it really happen? For a country of 140 crores, it's not so easy, but it is on the way. The efforts are being made, and every law focuses on public welfare. Even Limitation Act. So the court opined that the law of limitation is for the general welfare, that a period of limitation be put to litigation. That is, a litigation cannot carry on for time infinity. There has to be a time limit. The object is to put an end to every legal remedy and to have fixed period of life for every litigation, as it is futile to keep any litigation or dispute pending indefinitely. That's exactly what I told you. Now comes the beautiful part of it. What about if an order is or a decree is issued? What happens then? A right not exercised or remedy not availed for a long time ceases to exist. That means even a court order, even a Supreme Court order, does not exist for time infinity. If the remedy is not availed, it does not exist. Now, the Supreme Court has said that court has conferred discretionary powers to admit an appeal even after expiry of prescribed period, provided the appellant shows genuine or sufficient cause for not being able to file within time. But this sufficient cause is determined by the judge concerned, the court concerned. It has to be properly adjudged. It's not done on the basis of sympathy or empathy or whatever you can say. If someone has, and pertaining to uh, court orders, the court came upon and said that if some person has obtained a relief or just immediately when the cause of action had arisen, other persons cannot take benefit of the same by approaching the court at a belated stage, simply on the grounds of parity, equity, empathy, and compassion. A right or remedy that has not been exercised or availed for a long time must come to an end or cease to exist after a fixed period of time. So that means even a court order has got a fixed period of time. It has got a life of its own. And this is a very, very important aspect which we need to keep it in mind. And as we are, this is though Guide to IBC deals with insolvency bankruptcy code. But I want my viewers to not only to have knowledge about insolvency bankruptcy code. We need to have knowledge of the entire ecosystem. That is the law around insolvency bankruptcy code, so that my viewers can analyze a situation in the right perspective. So with this, we move to the next topic. Viewers, you can see on your screen the dashboard of miscellaneous provisions in corporate insolvency process. We are coming to section 242, which is power to remove difficulties. This is more of a suggestion to IBBI and the lawmakers. And the case which we are going to refer to doesn't have anything to do with insolvency bankruptcy code, but considering a lot of things this can have. Now, the topic says that if unfair, inequitable, or undeserved protection is afforded to a transferee pendent a light, a decree holder will never be able to realize the fruits of his decree. Now, this is the case of R. Savitri Naidu versus Cotton Corporation of India. Very recent Supreme Court judgment. Pendent in light means when the other cases are pending. I was initially of the idea that I'll put this case in section 100, wherein it is mentioned that the moratorium period is 180 days or approval of repayment plan. It actually does it, approval of repayment plan or unapproved repayment plan. When it goes to NCLT, it stays pending for months together. And there is no moratorium whatsoever. Secondly, the moratorium you get in section 14 and the pseudo moratorium, you get it under 33(5) in liquidation, are not the same. So a lot of complications can arise. So until and unless the lawmakers would look into it, there would be problems. And essentially, it is necessary to look into it. Now, this is the case. It's a very interesting case, small case, but very interesting case. A dynamic case, I would say that at that. Now, I would request you to go through this. Let me take you to the slide. Now, as I mentioned, in this particular case, what happened was there was a company dealing with Cotton Corporation of India. They had some disagreement regarding the price of cotton being charged. So the matter was referred to arbitration. Arbitration started in 1999 and the decree came out in 2001. Now, the company filed a petition for revision for challenging the order of the arbitrator, which was not entertained by High Court. So the order attained finality. They went for execution of the decree. But in the meantime, the company had availed loan from ICICI Bank. ICICI Bank instituted SARFAESI and was auctioning the property of the company. The managing director's mother bought the asset through auction. And as far as and ICICI Bank executed a decree, which is perfectly fine. Now, when the matter came to execution of the decree, there was no asset. The mother said that I have got no connection with your arbitration. I bought the decree through SARFAESI. I have the title. So ultimately the matter went to Supreme Court, and Supreme Court said a judgment debtor cannot defeat a decree by alienating the property after the decree is passed, but before the decree is realized. He should be careful before he purchases the property which is subject matter of litigation. An unfair, inequitable, or undeserved protection, if afforded to a transferee pendente like means pending the main petition. A decree holder will never be able to realize the fruits of his decree. From 2014 till date, the proceedings in execution are pending against respondent 2. I mean, what happens in this way? The Supreme Court categorically noted that judgment debtor would be incentivized to systematically defeat the decrees by transferring properties or planting surrogate objectors to initiate endless collateral litigation. Consequently, execution proceedings would not merely take 10 years, but would get trapped in infinite loop and practically never get completed, reducing the hard-won decrees to competent courtsmen to mere paper tigers. Winning a case is meaningless unless the winner actually gets the relief they sought. The arbitral award remains unrealized till date. Thus, the claim petition of appellant is rightly dismissed by the court below. So think of it. Why this is relevant? Because in section 100, the moratorium is for 180 days. Post 180 days, if the matter gets stuck in insolvency in NCLT for months together, anything can happen. Even with regard to proof of petition moved by a liquidator, 33(5) is not same as section 14 moratorium. So these are the things which needs to be looked into, and this case is an eye-opener for everyone. And this is extremely important. So with this, I take you over to the next video.
Viewers, we have come to the close of the presentation. We'll see you again after 2 weeks. Hopefully, by then, we'll have another lot of interesting cases and I'll be able to give you a good presentation. So, till then, bye for now.